Hello and welcome to Beyond the Gavel. Today's guest brings a distinctive and respected voice from the defence side of clinical negligence, one grounded in deep technical ability, a genuine commitment to fair resolution, and a passion for learning and patient safety. Jennifer Harris is a legal director at Capsticks and well known for handling complex high-severity claims including catastrophic brain injury, spinal damage, multi-limb amputations. Her practice spans not only serious litigation in the High Court, but what sets her apart is this strong education focus, where she helps NHS trusts, clinicians and other healthcare providers to learn from the claims, to strengthen communication, and ultimately that's about improving patient outcomes. So what sets her apart is the combination of advocacy with empathy, negotiating with conviction, yet never losing sight that there are individuals involved here, and there are systems behind each case. So through training programs and webinars that attract wide professional engagement, she has helped equip clinicians and organizations to navigate scrutiny with clarity, fairness, and with dignity. So today we're going to explore not only the realities of high-stakes clinical negligence defence work, but also how constructive engagement, early clarity, and well-supported witnesses can reduce conflict and foster safer, more transparent practice. So Jennifer, thank you for joining me, and it's a great pleasure to have you on the programme.
Thanks, Rodney. It's such a lovely introduction, so thank you very much. Pleasure to be here.
Well, I've been with Capsticks a long time, from my time in the college as head of education in the English College and things. So we've done a lot of work together, and I know, the webinars are very, very well received. So let's just start. How did you get into this in the first place? I mean, what brought you into the defence side?
Yeah, it's a bit of a long road. So law wasn't my first degree. My first degree was in English, but I realised very quickly that being a teacher probably wasn't the best way for me in a school setting, although ironically I have ended up in a sort of teaching role in what I was doing. But I love the law. I loved the challenge of working out from the evidence, navigating those arguments, trying to find the best way forward. And that's kind of what drew me to the law itself. I did personal injury law, so slips and trip claims for local authorities and things in the beginning. And that was a fantastic learning point. It was really great to engage with those local authorities. So I've always been driven to work for sort of in the public sector and supporting them. And then moved into clinical negligence because I thought actually there was some really great work I could be doing there in terms of helping to defend NHS organisations and healthcare professionals, but not with a sort of insurer mindset of just bottom line, looking very much at actually what is the fair result here, what needs to be done, and getting that compensation to those that have suffered harm as quickly as possible.
Yes, and I think that gets forgotten sometimes on the plaintiff side. They think you are a brick wall. And whatever, the defence says goes. But it is a matter of understanding that you're not perfect and I'm not perfect and none of us are perfect.
Right.
And things happen. Now, whether they fall within the legal definition of negligence or not is a different argument. But they happen and people are hurt. And so we have to think about that time, when the plaintiff is first seen by their own lawyers and what is going to set up a good case and what isn't. So from your point of view on the receiving end, if you like, of a claim, what distinguishes, one claim that's going to be one that you're going to try and negotiate out of and one that you're going to really, really fight hard for? How can we constructively look at that? How do you view it?
Yeah, and it is really difficult because it's about assessing risk ultimately. As you say, medicine is not straightforward. And the fact that someone's had perhaps an unexpected or not as great an outcome as they hoped, we know, there are inherently risks with medicine that there is sort of that factor there. So what we're looking at, though, is where it crosses beyond actually there was always a range of risk in terms of outcome to where something's happened or not been done that's caused some injury or made things worse. So that's kind of in very basic terms what we're looking for. And in terms of deciding whether a claim's one that we need to compromise, there are some that are obviously very obvious. If you've got sort of what we call never events where, for example, swabs have been left inside somebody and that's resulted in infection. That should never happen. That's a very straightforward issue. The ones that are more tricky are where, for example, there might be some element of the care that appears to be substandard, but there are two elements that a patient's got to prove to succeed in their claim. There's not just that there's been a failure in the care that it's substandard, but also that it's caused an injury. And the difficulty with the substandard care is that there can be a range of view. You know, there's clinical decisions have to be made, and no two patients are exactly the same. So a procedure decision or a medication given or a decision to hold back will vary so widely depending on the circumstances of that individual. So we really do have to assess these cases on a case-by-case basis. There's no sort of one-size-fits-all, sadly, which is what makes them complicated. And so what, as I say, we're looking for really is what has happened? Why has it happened? Can it be explained? Is it within the reasonable range of what the clinician ought to have been considering? Or actually, is it just, you know, badly timed, or they've got it wrong for whatever reason? We can't apply hindsight. We have to look at what they knew at the time. And that's really important to remember. I think sometimes it's very understandable that patients see an suboptimal outcome, or something has happened that they weren't expecting, and it's because of this surgery or this advice, and A equals B. And that's not always, you know, quite right. And there's a lot more going on in between. So it's up for us as lawyers to navigate that and try and explain that. So I don't underestimate the challenges that claimant teams have in terms of explaining that complex medical process and that complex medical legal test to their clients. But when we're looking at it, we're looking at for those obvious errors, or if there is something that's gone wrong. And if there's a range of opinion, then those are the cases where maybe we need to say, okay, do we want to be spending public money defending a case where there is a very real risk that actually ultimately a judge won't be with us? And so is there a way of compromising that with us both accepting that there's a risk to both sides? But sadly, there are sometimes cases that need to go to trial, and that might be because they've got an important point of law, for example. So recently, NHS Resolution, who we act for, who indemnify the NHS, have taken a couple to do with key issues like lost years, which is a very technical point. But also, for example, secondary victims, again, a legal point that needed to be determined. And so sometimes it's necessary to take those cases a bit further, or where, for example, we're completely polarized around the view of what the care should be or the value of a case. So it is a bit of an arc, or you know, in terms of assessing that risk. But to help, really, I think what I would say from the defendant side, the more detailed and clear a claimant's case is from the outset, the more accurately we can assess the merits or otherwise of that case. It's those ones where they've maybe not put as much detail that then lead us to have to take everything in a few more stages, and that can draw the process out. I'm sure perhaps you as experts, Rodney, find that a bit of a challenge when it's not really set out.
That is true. The one thing is the fundamental question, isn't it? And what I think a lot of plaintiff lawyers need to get hold of is, what is the fundamental question here? I mean, they have the story, and, you know, facts tell, stories sell, and they have this story and they have the emotion, they have all the rest of it. But you've got to get underneath that to the fundamental question. What is the fact, the one thing or the two things that are going to determine whether this is a case that should move forward or not? And as you say, you're clearly saying that. And if it ever ends up in court, what is the fundamental question the court is being asked to consider? So sometimes it's in a mist. You're trying to say, what exactly are you saying happened here and why? I think you've just pointed that out beautifully. So if the plaintiff's lawyers get that and say, okay, we've got to say, this is what happened, and this is why we believe this is true. So the fundamental question the court's being asked is this, one, right in fact, and two, therefore right in opinion? Those two things. So it's getting that fundamental question straight, isn't it?
Yeah, I think so. I think, you know, quite often, and it's understandable, I appreciate the beginning of a process, and it is a bit of a process of trying to narrow down the issues because, of course, the evidence is coming backwards and forwards. The good thing we have here in the UK is that it is a cards on the table approach. So we have to be very upfront about the evidence. We share evidence very early stages. And litigation is very much a last resort. So there should have been that exhausted process. But I think what can speed that up is, as you say, getting very clear about what it is you're saying should have been done. It's not just to say, well, they've had this outcome, so you didn't do something. You've got to explain and evidence what it is you say should have been done, when it should have been done, and why that would have made a difference. And that, I think, is sometimes it's that second part in terms of causation in the technical phrase that gets missed, I think. And that's where usually the battleground is. Sometimes the factual element of it, did it happen or didn't it, is relatively straightforward, but it's the so what difference would that have made that's the more challenging element of it, medically as well.
Yeah, they almost should have a crib sheet that says this, and the answer this, and the answer this and that. And before sending it off, you'd be able to fill that in. And then there you are. You've asked that. Here's the answer. You've asked that. And here's the answer. And that would actually cut out a lot of stuff. So that leads on to, I mean, they depend on their experts whom they ask. So what have you found among looking at experts? You deal with them yourselves from a defense point of view. And then there is the plaintiff's expert. And actually, probably there shouldn't be a blade of grass between them. If they're both doing their job and they're both advocating for the court and not for defense and not for plaintiff, they really should be very close to the same thing. So what are you finding about defense and plaintiff experts? What are you seeing in there?
Well, the first thing to say is that we're using the same pool of experts. A good expert is someone who does work for both sides, because I think that is important to keep that eye of balance and remember that the duty is to the court, not to your instructing party. So we do try to look for that, to make sure we get that balance, because an expert's role is to tell me what I need to know, not what I want to know. So that's sort of my sort of importance from their perspective. I think where you're right, it's very rare, I think, that you have experts in a very stark position in terms of absolutely saying it should have happened and absolutely it shouldn't. That is quite rare. And if it does happen, I think that raises some alarm bells around, have we understood what the issue is here? And one of the experts is perhaps not being as frank as he needs to be. I think why we end up quite often, though, with an element of dispute or risk is because there will be a range of opinion, and clinical elements are not very often straightforward. If it was easy, we'd all be doing it. It's not as simple as saying, well, patient has A, B, and C symptoms, therefore it must be action X. There are a lot more factors involved. And I think that is where you get your element of dispute, because there will be a range of opinion around A, what should have been done and when, and also what that might have done in terms of outcome. Particularly if if you think about obstetric cases, for example, you're talking about a matter of minutes and what could have happened in a matter of minutes and whether that would make a difference to someone's brain injury, for example. And when in minutes, when we as lawyers are looking at it very analytically, a lot can happen in a couple of minutes. But actually, when you try and put it into real terms, what does that mean physically moving around a hospital, getting those implements, getting that medication? That 2 minutes can disappear very quickly. And I think sometimes that is where the range of opinion comes with experts. And that is where there can be it seems obvious to the claimant that A is equal B, but actually when you look at it from a medical perspective, it's not quite as straightforward. And that's where that range and that conflict can seemingly appear. But we have to navigate that as lawyers. Judges have to pick a preferred expert. They can only pick one winner, to put it that way. A winner is a bit of a blunt term, I think. But we as lawyers have to navigate that by looking at the risk and saying, well, okay, is it going to be me that's preferred? What are the risks if it's not? And that's where the compromise element comes in.
Yeah, I have the pleasure of having met, a lot of people from the Sully crash on the Hudson River. And when that was being looked at by the FAA and the inquiry, they said, look, if they'd done this, and this immediately, they knew they had a problem with the bird strike. They could have got back to New York Airport. I said, no. When they were told, there's then a reaction time before they then say this. And so if the people who they got to test it, first of all, when they say go, they started immediately and did their plan, said, see, they could have just about got back. But when they say, now hang on a minute, you say, go, and then there's a, right, what am I going to do now? Think, and a couple of seconds of thinking, and even that 15, 20 seconds would have made a total difference to trying to get back to the airport there if we had to put it down in the river. But the inquiry took a long time to pick that up. And I think you've just hit it right on the head there, that it's not instant. I mean, the doctor has to see that the nurse has to engage that something is not right here, and it's not just instantly like that. So tell me about what you're seeing. I mean, you work a lot with medical professionals and nursing professionals going through this. Tell me what you see about their anxieties and things, and how that affects them over 3 to 5 years. What have you seen?
Yeah, I mean, I think, it's clear and obvious that a patient understandably is dealing with the immediate aftermath of any event, negligent or otherwise. So that obviously is distressing for them and the family. So don't underestimate that. But I think it can be forgotten that the clinical staff involved in that care are having to continue doing the day job and making very similar, if not the same decisions day in and day out, knowing that there is a claim there where someone is saying that actually you got it wrong. And I think that can be really difficult and challenging. They have to make these healthcare decisions with confidence. And so having a claim hanging over them can be really challenging, I think, in terms of that, because obviously they've still got to, no doctor, nurse, healthcare professional went into this job intending to cause harm. That is not their aim. And so it is very distressing to them when there has been an adverse outcome, and the thought of that potentially maybe they did get it wrong. And they obviously always will have some self-reflection immediately. So I think the anxiety around the claims process is firstly that frankly they never want to have harmed anyone. And so the fact that someone is saying they have it's impossible not to take that personally, even if it's the organisation that are arguably being sued. It's your care that's being criticised. And you've got to manage that for your day to day. Put on top of that this is a full-time job that they're doing, often more than full-time, because they're not doing normal hours like you or I, or not you so much, obviously, because you're in the medical profession, but like I
Thank
should
you
say.
for that. Yeah.
I, being a lawyer who's at the desk. But they're not doing sort of 9 to 5. And then I'm coming along 3 years later saying, so this patient that you saw, out of the millions that you've probably seen since, is saying that something went wrong. And I now need to go through in detail the records, everything you did, what you said, how you wrote it down, what did you mean in the records, and do things like detailed statements and detailed accounts from you. And that is a lot on top of the day job, let alone bearing in mind that, of course, a lot of time has passed, which means it is really challenging. I think adds, that process. So that's why we try to be as supportive we can, really, with that process and walk them through it. Be a point of contact. They can always pick up the phone to me directly. They've got my email. So there's a lot of interaction. Similar, I suspect, actually, to the claimant team. It's not this sort of faceless organisation. We do try to make sure that the clinicians are brought along and they have the internal legal team support as well. And we try to encourage that they have some sort of additional support, whether it's from a clinical lead or a governance and risk maybe member, somebody within their team at a senior level that can be there to just say, are you okay? Do you understand what's happening? Do you need any additional support? Because I think I can't even imagine it. If someone was really criticising me in a healthcare situation, I've got to keep making that decision every day. I think that's a really tough and brave thing to continue doing.
They've got to keep working. They can't just put their hands up and stop. No. And very few that I know stop and go off with shock or horror or anything else. They continue to work. Other professions say, "Oh, I think I'm going to be stressed and this sort of thing. So I need to go to my doctor and get some time off." But that doesn't generally happen within the medical profession. They keep going. And it is that. So how can they be better supported within their trust? What good practice have you seen, and what terrible practice have you seen in general?
I think, well, let's start with the terrible, because we'll get that out the way and then focus on the positive. So the terrible is really where there's been some sort of out of the blue email from us saying, right, we need all this information, please. They're not really supported in terms of giving that or giving the time to be able to accommodate and review it. And then they're just sort of left in the dark. And then I appear again several years later, asking more questions, because obviously from their perspective, it's sort of gone, it's come back, it's more anxious that way. Where it's done really well, I think, is where the legal team are very well connected internally with their divisional leads. They go via the divisional lead, warn that there's going to be this approach, there's this claim, we need to approach this doctor about it, so we're going to do that. I always encourage that the legal team introduce me, so that it comes from a friendly face, as it were, first. And then, as I say, we try to make sure we're keeping them in the loop, even if it's not me directly, if it's via the legal team. It's all about communication. And I'm sure that's, again, very similar in the claimant team. The better informed that person is around what the process is, the fact that it does take a long period of time, that there will be long periods of silence, but not to worry, that we will keep them informed if something's happening, and that we will keep them informed if it becomes necessary, for example, to make admissions and what the potential consequences of that are. Because obviously for individuals, quite often the organisation is sued. So in principle, there's no financial consequence for that individual doctor, but that doesn't mean it's not part of their annual review. If there are claims, they ought to be self-reflecting. There ought to be support to see if there was an issue, a gap in knowledge, for example. Can they fill that knowledge gap? Because everyone's at a different stage in their career. You don't wake up knowing everything in every circumstance. And then again, having that support for if actually, is there a problem here and do we need to look at that more seriously? So I think it's that holistic approach and remembering that the claims process is quite a small part and the medical element of it is actually much bigger. The claim is a sort of small aftermath several years later, and having just that better support.
You're doing that from Capsticks, and Capsticks are well known for doing that. You're well known for doing that. What have you found about the management, within the organization? Have you found that clinicians are well supported by their organizations to go through this process?
Yeah, I think.
Are they sort of HR dump on them and that's about it?
Well, luckily, it's not very often that it's HR that are dealing with it, I'm pleased to say, which I think does, I suppose, in some ways help. It doesn't feel quite so daunting in that sense. I think, generally speaking, more often than not, they are well supported, but I think it could be improved. I think, as anything with all of these things, it's about resource and time. Clinicians and clinical leads are also doing a day job. Just because they've got that divisional title, it's not that they're sat in an office escaping the day job in terms of doing medicine. So I think it's about working together with the legal team and the clinical divisions to make sure that there's that support. And sometimes I know some divisions have had, for example, champions, so who will help, particularly when there's inquests, for example, because that can be another quite daunting process for clinicians who have to give statements or give evidence to the coroner. And so they'll have champions who focus on doing that support, maybe across different divisions for someone who maybe is in a certain role that has a bit more capacity or that's their particular passion. So I think it's finding a balance. I think I like to think that they have, I certainly know from the legal teams and that perspective, they try to give as much support as possible. And I think clinically there's a lot of support, but it's resource. Like most things in the NHS, sadly, it's time.
Resource sometimes causes the problem, and then it makes it worse.
Yes.
We always hear this resources thing, but I have enough comment in a different category about the resource thing and who's what and who's doing what within the NHS. But that then leads me on to the other thing that we brought up today, which is your educational role. Mm-hmm. Tell me about the webinars and things that you all do and you've done for many, many years. What is it you're trying to do in those webinars and what's the results you see?
Yeah, so I'm really proud of the events program that we put on, actually. So every month, except for August and December, I do give myself 2 months off a year. We deliver a lunchtime webinar, like a lunch and learn session. And it ranges in topics from everything to sort of case law yearly roundups that are sort of aimed at just telling people what sorts of things are going on, to very specific topics such as, we've done a session on extravasation injuries and what type of claims might arise from those and best practice, maternity care, through to everything from sort of the claims process itself called a requiner. So we do a real range, and they're just snapshots on key thematic reports. If NHS Resolution, for example, has released a report that's looking at some issues to try and share that data and learning, but also topic specific, because I think we should aim to learn from the mistakes of others rather than repeat them. And I think the small part that the claims element can play, because obviously we aren't, it's a much bigger organisational issue in terms of safety and learning. But the small part that we can play is by saying, okay, well, look, this case, or these are the cases we see. These are the errors that get challenged and succeed, or are successfully defended or not at court, and this is why, and try to provide where we can some practical guidance. I know clinicians who attend my sessions will probably be sick of me, for example, banging on about good records. I know it's the bane of everyone's life because time is so short, but the reason we talk about things, for example, like good records, is because it's not about defensive medicine. It's not about defending the claims as such. What it's saying is actually, if you get that right, you're helping your colleagues understand what's happening, what's waiting, what the plan is, and who's responsible for the next steps. And actually, that in and of itself can quite often prevent the error or the issue arising in the first place. But if you are then faced with a claim, you've probably done the hard bit. You've made all the clinical decisions. You've given all the right advice. You've done all the right steps. But actually, we have to prove that, and we have to respond to the claim that comes in. And if you're not going to probably remember that individual, so something like records is a really good way for us to be able to bring back that to life, look at what happened, and the better they are, the easier your life is when it comes to me asking the questions.
Clinician, for a plaintiff, it's a one-off. It's them.
Correct.
They know all about it, and they read Dr. Google, Dr. AI, and all the rest. They read all about it. For a clinician, it's a face amongst thousands.
Yes.
And it's very, very hard to remember. So that record, and the other thing I tell people, if you have not done it and you know later on that something might go on, even if you write it down after 24 to 48 hours and say, this is a retrospective note. Now that can be criticized. I know that. But on the other hand, it's still within 24 to 48 hours of it happening, for instance, a birth injury. And it's close to the time, and you write it as full as you can. And we understand that it's with 48 hours of hindsight and hell what's happened here, but the better that is and the more factual that is, even if it is slightly late, is better than none at all.
Absolutely. And certainly it's going to be far more accurate than your recollection 3, 5, 10 years later when we're having the conversation. So the aim of the sessions really is, it's not to scare people and it's not to encourage defensive medicine, but it is to say, look, someone else has had to go through this horrible situation. What can we learn from it? Is there a better way to do it? And that focuses on practice for individuals, but also organisations. I've done sessions for those in primary care and looked at sort of what can be done better in terms of referrals. So I can't tell you how to be a good doctor in terms of the medical clinical decisions. I can't give you that advice. But what I can look at is, well, where have we struggled to defend a case and why have we struggled to defend it? And is there something about that best practice that we can share with a view to improving? And I'm very pleased to say that we get very good attendance every single month. And so I hope that means they are filling the gap and helping give that education, which again is perhaps filling a resource gap that organisations don't have the time or resource to do that training themselves.
Yeah, and I've said to plaintiffs' lawyers, saying, how close do you get to the defence lawyers? And what you're talking about, those webinars, would be gold dust to plaintiffs' lawyers, because they would understand what's going on the other side, and they'd understand better. I mean, okay, it says no, you're in it, but you still understand better what are the hooks, what are the sort of bullet points that you need to know. So maybe some of the plaintiff lawyers would be well off going to those as well to learn, the whole gambit, so that they can be better prepared for their job as well. And it makes everybody's job easier. Because at the end of the day, whether you're a lawyer or whether you're a doctor, a wise man learns from his mistakes, but a genius learns from the mistakes of others. You try not to make the same mistake again or you find that somebody else has done this and you know better yourself. So that education, that continuing education you provide is so valuable. Jennifer, it's been wonderful speaking to you today, and I really appreciate you taking the time out from your schedule to come and speak with us today. I hope the listeners have got a lot out of that, because I think you did an awful lot of great educational stuff there.
Oh, thank you so much, Rodney. No, I really do appreciate it. It is something, we're very passionate about here, about doing more than just the basics when it comes to our job. We want to be able to give that added value and make sure that we're supporting those that we do the work for as best we can, from beginning to end, but also hopefully getting ahead of it. So thank you very much. A delight.
Thank you.